Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Always down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Super weird. Hi, everybody. I hope everybody's doing well today. I apologize. I got sick last night and did not do members only, so I apologize. And then today, I think it was like food poisoning. I ate some questionable dip that I shouldn't have eaten. But then today, I spent the day like trying to make myself feel a little bit better. And I did it in what can only be described as a Paisley way. So had a little fashion show, determined that made me sad. I put on a bathing suit. I was like, you know what? You could wear a bathing suit tonight, like just the top part, it'd be all good. And then all my brain could think of is like, you're not going on vacation anytime soon. What the fuck do you need a bathing suit for? Take it off. So Paisley's brain is being mean to her today, which is grand. Also, I had a hell of a time getting the court today. Wouldn't download on any of my best sites. Wouldn't do it. So I have it got another way, and we'll see how that goes. But that was really fucking up the stream. So we're going to start with this video that doesn't seem to be fucking up the stream, and then we'll go from there. If you would like, tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. I'm not very hungry, so I'm not going to eat right now. Alas. Oh, yeah. If anybody's wondering about, also, I don't know what this case is. Hopefully it's something. 11 minutes. Oh, I do have that other Kirkham case I could do. Anyways, also, we have tomorrow, probably back to that petty ass divorce, St. Jacob. If you haven't heard of that one yet, go check it out on the site, on the page. I've linked them all in like yesterday's video. I think I linked them all. Sometimes we are gluttons for punishment.
So fast, I didn't get a chance to put this up. Just had to take care of him. It's just one. Someone's trying to get in. Oh, yeah, two people are supposed to come back in person. It's on that sheet. Yeah. But Dana doesn't have any audio.
Yeah, it's super petty, Bev. Gave me a bit of a headache. It did not make me sick. That was something else. But it's giving me a headache too. I'm scrubbing this to see when the judge shows up. Finally, here he comes. Okay.
Maria, so do we want to put the language as far as the 6 months, or just want to go to Judge Lemire if we want?
I think we can state on the record that both parties agreed that they have no objection to waiving it, and then we can figure out the insurance stuff and just enter it when it works.
Understand.
Court is now in session. Adding on Dana Moore versus Troy Moore.
For the record, this matter is before the court in the absence of Judge Lohmeyer. To place a settlement agreement upon the record. This hearing is being conducted via Zoom. Present is Attorney Jason Kazmarek, representing the plaintiff Dana Vore. Ms. Vore appears to be present. In addition, Attorney Maria Zagorski is present, representing the defendant Troy Vore. Mr. Vore appears to be present. Good morning, everyone.
Good morning, Your Honor.
Morning, Judge.
The parties meted with Mr. Walker and reached their own agreement this morning. Is that correct?
Yes.
It is.
Wonderful. Who would like to place that agreement on the record?
Do you want to do it, Jason, or do you want me to do it?
That's fine. I can do that.
Okay.
So, Judge, the parties have one minor child together, Troy Anthony Vore Jr. With regard to that minor child, there's going to be joint legal, joint physical custody. Parenting time will be reasonable and liberal to both parties with the intent of having 50-50 parenting time. Support will be reserved. The uninsured medical will be paid 50-50 with Dana Vore, plaintiff, to cover the insurance. Regarding tax deductions and credits, for future years, Dana is going to have the even year tax deductions, where Troy will have the odd year tax deductions and credits. Regarding spousal support, that's going to be barred as to both. There's real property located at 1135 South Park Drive in Temperance. That property will go to Dana, the plaintiff, and she's going to pay. There's a total equity amount of $25,000 that's going to be paid, which includes the marital home and other items. So $25,000 total equity is going to split between vehicle, real property, and some retirement accounts. But Dana will keep the real property at that address. With regard to vehicles, there's a 2012 Dodge Journey that's awarded to Dana, a 2018 Jeep Grand Cherokee that's going to be awarded to Troy upon the payment of a loan. So there's currently a loan in the name of Dana. That vehicle will be going to Troy once that loan is paid off, and that's been paid off in conjunction with payment to Troy. In the meantime, Troy is going to pay for the insurance, going to reimburse Dana for the insurance for that vehicle. There's also an 89 Mustang that's going to be sold. The first $4,400 of that sale are going to go to Dana to pay off a loan.
89 Mustang. I'm sorry. I gotta get a fucking cost on that. You gotta be joking me. That's not classic. Is that classic? Oh, I gotta take this call, you guys. I'll hit play.
For that motor vehicle, the remaining value is going to be split between the parties 50-50. All the personal property is going to be as agreed. Debt is going to be paid by each party in their own name, so there's really no joint debt. Each party is going to maintain their own debt in their own name and hold the other risk not harmless as to that debt. I'm sorry. Bank accounts, each party is going to keep the bank accounts in their own name. Retirement accounts the same. Again, that's part of the equity transfer, but ultimately each party is going to keep the retirement in their own name, as well as life insurance in their own name. And Dana will have the maiden name returned of, I forgot the maiden name was, how do you say it? How do you say your last name? Versher. Which is spelled Verscheure, if she so chooses. And regarding the $25,000 to Troy, that's going to be paid within 90 days. If that is not paid, the house is to be sold with the first $25,000 to go to Troy. And I think that is the entire agreement.
Thank you. Ms. Zagorski, did Mr. Kazmarek accurately state your client's agreement?
Smoking in court. Did Dana just smoke in court, you guys? I'm literally watching this. I swear to God, I think Dana, look at her. I'm pretty sure she's smoking.
$5,000 to Troy, that's going to be paid within 90 days. If that is not paid, the house is to be sold with the first $25,000 to go to Troy. And I think that is the entire agreement.
Thank you. Ms. Zagorski, did Mr. Kazmarek accurately state your client's agreement?
I believe so. I think it's understood that once the loan on the Jeep is paid off, she'll provide my client with the title. And those exemptions, mom is going to take even tax years and dad will take odd tax years. And then, did you say standard life insurance provision, Jason?
I did.
Okay. Then yes, that is my client's agreement. Thank you.
Mr. Kazmarek, are those clarifications agreeable?
Yes.
All right, very well. Mr. and Mrs. Warwick, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I'm sorry, both need to speak up.
I do.
Thank you, thank you. We just need to capture responses to all the questions put to you this morning, so thank you. All right, Mr. Kazmarek, you can begin with the Ms. Warwick, please.
Yep. Dana, please state your name.
Dana Marie Moore.
You reside in the state of Michigan for at least 6 months prior to the divorce filing,
Yes.
and resided in Mineral County for at least 10 days before the filing. Is that correct?
Yes.
And you're married to Troy on or about August 26, 2018.
Yes.
Are you currently pregnant?
No.
You have one minor child. Is that correct?
Yes.
Is that Troy Anthony Vory Jr.?
Yes.
And do you believe the marriage is broken down?
Yes.
Can it be preserved?
No.
Are you asking for the option to end this divorce prior to the 6-month waiting period? And you have a right to have this divorce go minimum 6 months. There's a cooling off period in the state of Michigan. You can also elect, if you choose, to waive the 6-month period. Do you
I
wish
waive
that to
it.
be waived?
Yes.
Do you believe that would be in your best interest and Troy Jr.'s best interest?
Yes, I do.
And the agreement stated in the record is your full agreement?
Is she crying? I know, I don't know if I believe her after the last case. If you haven't checked out that case, I should put that down. But guys, sorry, that was my daughter. I forgot to mention that's another reason I'm having a bad day. Her bank card got compromised today and somebody stole a bunch of money from her. So that was just an update on that, which they're working on it, but it takes a long time. And then, yeah. And then I see this lady vaping and I'm like, what the fuck? She vaping in court? My daughter is laughing at me on the phone because I was like, hold on, I gotta say this because I think she's vaping in court. She's like, Mom, what? Yeah, it really sucks. I'm pissed off. And she didn't do anything wrong. Like somebody, I don't know. I just guess they had the details. I mean, it's hard. I know she doesn't share out her card, but anybody, it's just the way it is. So, but I told her, and she knows because I used to work at the bank, and she knows how to respond to things like that. So she knows, and they are like dealing with it fraud wise. I just said to her earlier, I was like, do you tell them that if we need to, we'll call the police and they'll do the investigation. If the bank's not willing to take care of it properly, then yeah, it could be anything, any number of things. So yeah. And then we were finalizing our Mother's Day brunch plans, and she's behind the scenes at the musical this week. And so we were talking about which day of the week I'm going to go to that, which means I will be off one of these days, but it's for a very good reason.
Yes.
You understand you could have gone to trial, you could have got more, could have got less, but the terms stay in the record today, your full and final agreement?
Yes.
Did you state all your assets?
Fletcher boy, thank you so much. Do. Love you so much. There's no vaping in court, Dana. Stop it. And I did not have a kid at 16. My kid is almost 16. I keep saying that. I'm 20 years older than her. I was pregnant when I was 19 and I had her when I was 20. So I just avoided teenage pregnancy, basically. I think it's going to be Thursday, but I have to check on the tickets online that I have to go buy, and I have to find out how much they are too. So.
Yes,
Does Troy know all your liabilities?
yes.
I have nothing further.
Thank you, Mr. Kaczmarek. Ms. Gorski, do you have any questions for Ms. Vore?
Just one. Ms. Vore, do you believe that the custody and parenting time agreement is in your son's best interest?
Yes.
Thank you. That's all I had, Judge.
Thank you. Right, Ms. Gorski, questions for Mr. Vore, please.
Thank you. Troy, would you please state your name for the record?
Troy Anthony Vore.
And you heard your wife's testimony today?
I did.
Was it true and accurate to the best of your knowledge?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay, sorry, I didn't understand you. And you similarly believe that the custody and parenting time is in Troy Jr.'s best interests?
I do.
Do you believe
Is he wearing his sunglasses just like slightly above his eyes like this? It is possibly the most distracting way I've ever seen somebody wear their sunglasses. That is so weird. It's very common here for children to have bank accounts and for them to be given debit cards with strict limits on them. I opened many a bank account for many children when I worked at the bank. My daughter has had a bank account since she was probably 6 years old with a debit card. Yeah. Not that she carries it with her or carried it with her as a young child, but it's very common here. It would be standard issue. And now she's old enough. She doesn't have a job except unless you count getting money from me and her dad and her grandma and her everybody. Then she does pretty good. So
that the property settlement is fair and equitable?
I do.
You understand that if the court accepts your agreement today, it becomes final and binding and you can't come back and ask the judge to change it? You do understand that?
I agree. Yeah.
Okay.
I understand.
If we wanted to have a trial in this matter, the court would have conducted a trial and you could have done better or worse at that trial. But you understand by agreeing to this today, there will not be a trial and this will be contained in a judgment of divorce.
Yes, ma'am. I understand.
Have you disclosed all of your assets?
I have.
And do you understand the agreement that's being placed on the record?
I do.
You have any questions of me or anybody else?
Nope.
Okay, thank you. That's all I have, Your Honor.
Thank you, Ms. Gorski. Mr. Kaczmarek, do you have any questions for Mr. Vore?
I do not. Thank you.
And Mr. Kaczmarek, you'll prepare the judgment, is that correct?
That's correct.
There will be food trucks and entrance fee from 11 to 3 today.
That's correct if you didn't hear me. I'm sorry.
Okay, I don't know if Ms. Vore had any questions.
what the heck was that? I'm starting to think that maybe it was a weed vape, not a nicotine vape with her giggles, allegedly. What was that? That was super weird. It sounded like it's some automated thing. And bikini, I never said bikini. I said bathing suit, first of all. Second of all, when I have a vacation booked, I will model bathing suits. Until that time, we all suffer together.
Oh, did you have a question, Dana?
No.
Okay, all right. Very well, at the request of both parties, the court will in fact waive the statutory balance of.
Also, I checked into the car, the 89 Mustang. So the thing is, if it was a GT Cobra, the 5 liter or the 5.1 liter, one of those things, then it's possible it could be worth like over $5,000 US. But for a regular 89 Mustang, no. Probably not. So I don't know if these people live in Wishtown, USA, where they're like, yeah, my 89 fucking V6 is going to do great. No, it's not going to happen. And I have a feeling like if it was the GT Cobra Mustang, is that what they're, I think that's what he said. Anyways, that they would have said it. Otherwise, I think they're just wishing and hoping and praying. And if I were her, I don't know if it's better to inflate the price of that or not. I don't know in whose benefit that goes to if they haven't sold it yet. It would be one thing if he was like, yeah, I just sold it for $4,500. Okay, well, Paisley's wrong, but they plan on selling it. Yeah, rent must be due. Rent's overdue. I wish, but I don't steal shit.
The waiting period, the judgment can be presented to Judge Lohmeyer for signature, but at least it's captured on the record. I would like to thank and acknowledge Mr. Walker for his assistance, as well as, of course, Attorneys Kazmarek and Zagorski for helping facilitate amicable resolution between the parties. Based on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the judgment, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter, granting a divorce from bonds of matrimony. Good luck to you, Mr. and Mrs. Ward. That will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor. Appreciate your time.
Thank you.
Welcome.
All right, case number 1, done. Okay, the next case that we're going to do is the TPO case. We're going to start it. It's in Thurston County. Like I said earlier, I had issues getting it, but I will grab it here in a second. I will probably creep frame as I do. So let's just make sure I don't have an ugly face when I do that. Okay, like I said, this is Thurston County, and it's going to be a TPO case. Oh, and at the beginning it was really
Morning.
Take a pick. All right, we have Ms. Hobson present and Ms. Robert present. And Mr. Robert is present and Mr. Landis is present, all of those by Zoom. So Ms. Robert, Mr. Robert, and Ms. Hobson, raise your right hands for me, please. Swear that testimony in this case to be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. All right. I know I saw the parties on Friday in regards to the appeal of the small claim ruling.
So I went to look for the small claims ruling from Friday, but everything had been deleted. I went back and looked in my records and I had downloaded a small claims hearing, but it wasn't these people. So I don't know which one it was that they had, but sounds like they had a separate small claims case. And now this has become a civil TPO hearing, which is sort of weird.
And I had told you at the time, I knew you were coming into court today. I had previously reviewed the petition in this case, and so I am familiar with the issues raised. Ms. Hobson, Mr. Landis is serving as your counsel, is that right?
That's correct.
Okay.
Yes, Your Honor.
All right. Frankly, I'll just ask, well, since you're represented by counsel, I'll go through Mr. Landis. Mr. Landis, as I've indicated, I've read Ms. Hobson's petition. I've reviewed the other documents and also reviewed the response from Ms. Robert and associated documents. Do you have any other factual testimony you wish to have elicited prior to making argument in this case?
I don't believe so, Your Honor. If Your Honor has any particular questions or if something comes up from Ms. Roberts' testimony or Mr. Roberts' testimony, we'd like an opportunity to respond if need be, but I think the record is pretty complete in terms of the evidence that we have filed.
All right, thank you. And both parties have filed fairly extensive evidence, and I have reviewed it. So I just want to indicate that to the parties. All right, Ms. Robert, do you have anything you want to add that's in addition to what you have already filed?
There was new evidence presented and I quickly responded.
Okay, you're going to need to really speak up because you're coming in very soft.
Okay, can you hear me better?
That is better, yes.
Okay, thank you. The response filed by the petitioner just a few days ago, I attempted to respond to rather quickly, but they brought up new questions regarding why we hadn't filed any additional or served them with any additional official notices from the property manager. And she's here as a witness just in case that's even relevant.
Okay, and is that Ashley or Kylie?
That's Rachel Taylor.
Rachel, I'm sorry. Okay, I bet I know Ashley and Kylie. Okay. And so nothing else factually, Ms. Robert?
No, I presented everything.
Right, thank you. And Mr. Landis, on behalf of the petitioner, your argument. And once again, I read your declaration that you had filed recently.
Thank you, Your Honor, and I appreciate you going through the record. It's fairly long and voluminous. I think just to simplify and cut to the key elements here, the respondent doesn't deny that there was electronic surveillance of both of my client's children and at least 6 of their friends on multiple occasions. The justifications that she provides don't really hold water. Primarily, the law does not immunize unwanted surveillance or monitoring or tracking, even if it's on a public or open portion of a social media site. The key is whether that monitoring and tracking makes someone, adult or child, feel frightened, intimidated, or threatened. In fact, the worksheet for the protective order petitions that the court issues makes that clear. It specifies 3 questions that a petitioner has to answer. One is whether the other person has contacted, attempted to contact, monitor, or tracked, kept under observation, or follows you. Number 1. Number 2, that the behavior happened 2 or more times. And number 3, you feel intimidated, frightened, or threatened. And in fact, the respondent does not contest that my client's children felt intimidated and threatened. And in fact, the same is true of the 6 other children, minor children, teenagers, that were contacted multiple times on the social media sites. One of them, in fact, made it clear that Ms. Robert had done it again, and it was actually scary. And what concerns us in this case is that even after Ms. Robert was notified by my client of the concern to her children and a request that it stop, and even after my client notified her other landlord, Ms. Roberts' husband, at length about the concern that she had and the concern for her children's well-being. There was no response whatsoever. Not at all. No shred of concern has ever been exhibited by the respondent for that issue, which is really the key to a protective order. In addition, the respondent did try to contact or access the private sites several times, not just once, several. Once in April 2023, she attempted to access the private portion of Juliet, my client's daughter, her social media site on Instagram. She was blocked. Then earlier this year, she tried.
Mr. Landis, let me interrupt just so we can make sure the record's clear. And by access, you mean by submitting a request to either in friend and Facebook, or I can't remember what they call it on Instagram, but you have to file a friend request essentially, and that's what you're referring to?
Yes.
File a friend request. I don't know that I've ever heard such a weird way of describing Instagram requests, I guess. Hi Donald, I'm doing pretty good. I'm getting better-ish. Yeah. File lots of friend requests, right? It makes me giggle. I don't know why. Yeah. Oh, so okay, here's what I figured out. Rebecca in the middle is the respondent. James on her side is her husband. They own a property that the lady who's sitting in court rented, I'm assuming. I have to assume that there was some sort of damage supposedly done by the children, and this lady has been reaching out to the children and the friends of the children of this tenant, former tenant. And then Greg Landis right here is the lawyer. Rachel is the new property manager. Rachel is on team Rebecca. Okay, Rachel is a bit of a bitch, allegedly. Jeez. Read frame. That's not good. Donald, I think that you may have creed framed it, but I love you too. Thank you. Let me just play thank you. Damn it.
Your Honor, that's essentially right.
Can you see it? Because I can't see it.
That happened.
Hold on. I can't see it. I gotta see it. I gotta be able to see it. You can't see it either. Hold on. Let's just get a number for 827. Okay.
Yes, Your Honor, that's essentially right.
Okay, all right, go ahead.
And so that happened twice, as far as we know, to Juliet. And the second time was earlier this year on a different social media platform called Snapchat. And in that same week, Ms. Robert requested access, again, requested being a friend to one of Juliet's very good friends, Lauren, also on Snapchat. So the key here is that this happened multiple times. There is no defense that it was only on an open portion. That isn't something that the law immunizes. And finally, and most importantly, it caused emotional distress, considerable emotional distress.
Is that a bingo apparatus behind James? You guys? It looks like a bingo calling ball. What is it?
To my client's children and her friends, and my client and her husband as well.
All right. Thank you, Mr. Landis. And Ms. Roberts?
Good morning, Your Honor. I'd just like to respond kind of point by point. I absolutely have not attempted to contact in any way these youth. I have not messaged them, emailed them. I have only viewed the profiles. It's, as I said in my answer, it's possible that on Snapchat, the follow button is rather large. And when you're on your phone, it's super easy to hit a follow request and attempt to follow that person. It's not like a friend request. It's just, Snapchat doesn't even have like, it's a messaging platform. It's not really as.
Ma'am, don't try and tell us what anything about Snapchat. Okay? Did you get Snapchat just to creep on these kids? You can't tell me you had Snapchat. Do we think she had Snapchat already? Rebecca up there talking? Seems weird.
As far as I'm aware, it's not like stuff that you don't post things. And I have no need to be friends with these kids. I have no need to message these kids. I was just screenshotting the evidence as I saw it on social media of parties at our house, things involving our house, and multiple children, multiple youth that are at the house are simultaneously posting, hey, here's a selfie. We're at a party in the backyard. Here we are with all of our friends of like 25 and 30 kids. And the petitioner had previously been put on notice that this was absolutely unacceptable in our property. And, they're climbing in the trees, they're dancing on the roof. And
oh my God, they're climbing trees? Wow. Are they drinking? Did you call the cops? I don't know that you're allowed to say who is allowed to be over if you rent the person a house. Like, you can't, can you do that? Exactly. Like, as long as there's adult supervision and it doesn't get out of hand, why would that be? This is weird. Ma'am, you don't need to rent your house then. Doesn't sound like you're a good person to rent a house from. You probably want your house to be your way. And when you rent it, it's just not.
so I just merely was trying to document the evidence of the lease violations and the shenanigans that were ongoing. I've never contacted any.
Shenanigans. Okay, I don't know. I feel right, Rebecca? Yeah. I don't know. She doesn't seem very good at hiding it. Oh, man.
anybody. I've never messaged anybody. I've never followed anybody, attempted to follow anybody.
Wait, doesn't Snapchat give you a notification when somebody screenshots your stuff as like a protection? So these kids are probably getting alert after alert of her screenshotting their posts. I know there's one platform that gives you an alert or prevents you from screenshotting it, one or the other.
We live 2 hours away. I'm not we're not at the house while they were living there, trying to monitor the comings and goings. I have third-party reports coming to me from the neighbors who I know because we lived in that home for several years, and they are telling me, hey, there's another party at your house. There's another thing happening. There's cars lining the street.
Oh, you got a Karen snitch. You got a Karen snitch in the house who doesn't have the balls to go to the person and be like, hey, you're doing nothing illegal and it bothers me. Instead, they run to Rebecca and they're like, oh my God, Rebecca, you would not believe how many cars were parked on the street. Okay. What the fuck is wrong with you people? Get lives. Get lives.
I've produced multiple pieces of evidence of the documentation that came from social media, that came from public, open social media. So I have no reason or desire to be contacting these kids, and for that matter, for the or anyone related, friends, whatever. So I don't believe that they're afraid because all their social media things are public. If they're afraid, they'd make them all private. They're all public. They post stuff out there because they advertise parties online and they want everyone to see what they're up to. It's part of that, youth culture, but it requires, in my opinion, it requires parenting to say, gee, what are you putting out on social media? And what does that say about you?
You can't tell somebody how to parent their kid, you dumbass. What is going on here? Is this a real case? The problem is that they're tenants. So it's not like, I don't know. I wish I had the small claims case. Like I said, I went back and looked. If anybody has it from last week.
You and what you're doing. And, when they're posting photos with, beer cans in hand, it's evident what's going on. And I merely was trying to document that for our own purposes because these people were renting our home. And over the course of 3 years, there is extensive damage to our home.
It's 3 years that somebody lived there. So you go through the proper channels. You don't go through Snapchat and message people's kids. If they have it on public, then that is probably not going to be stalking. But it is creepy. But if it's publicly available, I don't know. Also, that's what you keep a damage deposit for. I'm sorry, but there's also regular wear and tear on a house after 3 years. I hate fucking landlords. They're like, oh my God, my house isn't perfect after 3 years of people living in it and paying me thousands of dollars a month to do that. Ugh. Terrible. And it's as a renter's fault that you fucking rent it out and have multiple properties, which is what you said, and you pay the mortgage with it. You don't have enough money saved over to do the renovations that need to be done when it needs to be done. Hi, Alana. Getting mad now.
and it's kids running amok and just people not taking care of things, people claiming no responsibility for damages, for behaviors, even though they say in an email, yes, I'll make sure this
Okay, I'm not the small claims court, so I'm not gonna get into the issue of
I understand.
damage and responsibility.
The line's definitely blurred.
All right, so Ms. Robert, you'd indicated that you had made no attempts to contact them, but I saw screenshots of at least 2 friend requests. So to me, that seems like a desire to contact or to get access to private displays.
Which screenshots are you referring to? So
Well, your name appears on a couple.
That's just that I viewed the profile, or that I viewed the open profile, not that I was attempting to be a friend. And I think they're the same one, even though they're listed separately. Let me find.
Okay. Yeah, I mean, my understanding is those are friend requests where you're asking to participate in their particular postings. I don't know that that automatically happens if you just log in and look at their site.
For Snapchat, that's the one I think was inadvertent. Like you can just be scrolling on your phone and accidentally hit the blue bar because it goes all the way across, and that then sends a follow request. It's not a message. It's not anything. It was inadvertent. It wasn't on purpose. My phone is fairly small.
It is a message though, Rebecca. Even if you don't want to think that it's personalized from you, it's a fucking message. It comes in as a message. So-and-so wants to be your friend. So that's not true. That is a message. And I don't give a fuck if it was by accident. Maybe you should have been using your iPad.
And it's easy to accidentally hit it, I guess, when you're looking at the open profile. Like, it's a public profile, anyone can look at it, and then to accidentally hit the follow button is something that is very easy to do and wasn't done intentionally. The Exhibit 4 is the only one I see where there's a request. The rest of them just say that I viewed the profile along with multiple other people who are also not friends who have viewed the profile. That's all I see. One accidental on Snapchat. On Exhibit Exhibit 4. When it says follow next to it and it's red, you press that button on TikTok if you want to follow that person's TikTok. That was not what I was doing. I never clicked that. If I did, it would say follow back. Exhibit 3 and Exhibit 4 are exactly the same incident. So it shows Exhibit 3 that I added someone on Snapchat, and then it shows an Exhibit 4 except, added except friend. That's the same situation that happened one time, and it was accidental, and it was a year ago when I was first looking at all the social media, trying to determine what was going on at our house because of the.
Okay, and Exhibit 6.
Exhibit 6. Exhibit 6 just shows that profile views. There's 2 Exhibit 6s. One says 907 at the top, and it just shows that I viewed a profile. It doesn't even show whose profile I viewed. And the second Exhibit 6 shows 108 8 at the top. And that again just shows that I viewed a profile, not that I attempted to follow them. Just that I.
Okay. All right. Thank you. Mr. Landis, you get the last word.
Your Honor, as my client's declaration and her initial petition makes clear, there were multiple attempts to access, but not only of her children, but at least one of the friends. As you can imagine, it is the only way to capture that evidence is if the child at the time takes a screenshot of the attempt. And what we provided were examples, and it's not exhaustive. I'm relying on the declaration of my client, and certainly if it becomes an issue, we can ask each of the other friends, the other minors, to submit declarations. But I think the important thing here is that whether it's on a public, whether she accessed a public portion of the site or tried to get access into the private portion, the law makes no distinction between the two. The law forbids unwanted surveillance, even if it's through, peering through a binoculars on somebody's sidewalk or a public park, or following them. It's that there is no distinction that the law makes that requires actual intended access to a private portion of a social media site. But Your Honor, I would like to make a suggestion about how I think we can resolve this dispute fairly readily, if Your Honor is willing to hear that.
Go ahead.
My client and her family have moved out of the house. The tenancy is over. And so the justification that Ms. Robert has provided to previous monitoring of the social media sites, whether or not it was legitimate at the time, it is no longer any reason whatsoever to conduct any observation of public or attempted private sites. And so if Ms. Robert simply promises here in court not to continue the behavior, not to do it again, and apologizes for any emotional distress that has been caused to these children, then we will withdraw the request for the protective order.
All right.
Okay, so at this point, I paused it and got another one. It said it had downloaded, and I was like, fucking great, because I've been fucking recording this because it didn't download. And then, in fact, it didn't download. So it's in 2 parts. Give me 1 second. And guess what?
All right. Thank you. And Ms. Robert, do you want to respond?
Yes, Your Honor, there is one more thing I wanted to respond to, and that is, we actually hired a property manager for the.
Right. Okay. Okay. Hold on. Just with Mr. Landis has indicated there'll be a withdrawal.
The guys in the truck suck. I wish I had guys in the truck. It's getting better now. Hold on.
Respond.
Yes, Your Honor, there is one more thing I wanted to respond to, and that is, we actually hired a property manager for the.
Right, okay, okay, hold on, just with Mr. Landis has indicated there'll be a withdrawal of petition for an order if you're indicating you have no desire to further contact the parties.
I agree, Your Honor. I have no desire. The only contact I'm going to need to have is with the parents, and that's regarding damages to our home.
Your Honor,
Okay,
Your Honor,
hold
may
on.
I say something? Only because of the fact that in regards to this situation, I feel that the testimony from us is actually super important because there is a piece in regards to what Greg is saying, in regards to his request for her to cease those things because they're out of the property. I would like to state that the Roberts actually came and hired management because they wanted no further contact with them due to the fact that the harassment from what the only reason I feel like this is somewhat
Ms. Taylor,
relevant.
hold on. Ms. Taylor, hold on. What's your relationship here? Are you one of the property managers? You're muted.
Yeah, and the reason I feel it's somewhat relevant is because
Okay, I'll decide whether I need you're one of the property managers?
yeah, and the owner of Pettit Property Management, yes.
Okay, so do you agree that Ms. Hobson and her family have moved out?
They have vacated the property, correct?
Okay, all right. Okay, so I've heard thank you. I've heard Ms. Robert indicate that she has no further interest in contacting the children of Ms. Hobson, either directly or indirectly. And no, obviously, and Ms. Taylor is the one responsible for closing up the property and moving it along. I can't imagine any interest you would have in the activities of the children going forward. Is that accurate? Ms. Taylor, is that accurate?
That would be accurate. My concern is that Greg Landis has actually told the tenants, even though they have vacated, in multiple correspondence since we took over, that we are not the point of contact. And they refuse to go through us and keep going to the Roberts directly due to his, and I have written proof, his direction.
All right. Thank you, Ms. Taylor.
That's why I think it's important.
I'm not going to get into that. Okay. Mr. Landis is their attorney, is representing them, and he'll take actions he believes is appropriate. So, all right. I'm going to note the withdrawal of the petition by Ms. Hobson and indicate that Ms. Robert has agreed not to reach out to the children, and this doesn't, this doesn't create a barrier to the parties, the adult parties contacting each other in regards to the current ongoing dispute over the tenancy and any damages that may have resulted therefrom and the return of the deposit. Those issues are issues that adults are fully capable of handling through the processes that are created. And that would be the expectation. I will say, frankly, that this was going to be the result, in my mind, whether Mr. Landis had suggested it or not, because I do think that hosting things in public arenas is basically inviting observation. So as I suspect lots of landlords review public postings of tenants to make sure that what they're seeing is appropriate. If people want what they're doing not to be observed publicly, they probably ought to take more precaution. Who else does this? Law enforcement does it. The number of convictions that are obtained when somebody posts things online and, I wasn't there, but then it shows them there with the knife or the gun in the hand, whatever. Who else uses it? Schools, kids applying to college. What do they like? Colleges peruse their social media all over the place, looking to see what are they really like. So it's a fairly common thing, and the expectation these days, and this is coming from somebody, me, who I am on no social media, so for a very intended purpose. But those who decide to put themselves on social media are opening themselves to observation by folks way beyond their intended audience if they put it public. And so there just ought to be caution. And Ms. Hobson sitting right in front of me, and she's hearing me say this. And I'm just indicating that from where I sit, that would be, I would hesitate to restrict people's ability to observe what is appearing in front of them directly. Now, I also agree that since the tenancy is ended here, there would be no basis for Ms. Robert or Mr. Robert, or in fact, Ms. Taylor and the agency that is administering the property to then peruse anything going on with the kids unless somehow they show up back at the property having a big party or whatever. But beyond that, they should not be observed in their social media gathering. That would then indicate to me a surveillance that's going on, because there's no reasonable issue that either the Roberts or Ms. Taylor would have in the activities of the Hobson family. So I will sign the denial order with that understanding that there will be no further looking at the public media of at least the children of Ms. Hobson. And the parties as adults can continue in their attempts to resolve the legal issues that have previously been before the court, and I know are now moving on to an appellate review.
Can I
All
ask-
right, and Mr. Landis, I'll sign an order to this effect, and it'll be available in the district court file for the parties, and same for the Ms. Robert. I'll
Thank you.
sign a denial order. Okay.
Thank you, Your Honor. We appreciate your guidance in this matter.
All right. Well, thank you all. Okay.
Thank you, Your Honor.
You're welcome. Thank you.
Was she filming at the end there? I just saw that. I think she was. I'm pretty sure that she was filming at the end. Her phone was up. Anyways, guys, thank you so much for putting up with my internet problemos. That was an interesting case. I'll still work on finding the small claims details. I think it would be an interesting case on its own, but I'm getting Karen vibes. I think and this is why it's so smart to get a lawyer, because that lawyer just bossed that almost. Like, wait, did they agree? They agreed to put the order in place, saying that she won't do it. But yeah, so that seems, again, as soon as you agree, everyone's like, the judge is like, perfect agreement, let's be done. I don't care to hear about your problems. Thank you guys so much for being here. I really appreciate each and every one of you. If you are new or if you've been here since day one, I love and oh, look, these are gonna look like something bad or something. They're just my loops for my hoodie. Anyway, oh, and my hair, look at that. Anywho, I hope everybody has a wonderful evening. Remember that I love you, I am proud of you, and I will see you in the next video. Bye.